So, John, it's good to have you back on again. Wanted to have you back to talk about the state of the court system right now.
Thanks, Jason. Always a pleasure, and happy to see you virtually. Wish I could see you in person, but I enjoy our virtual chats, and very interested in informing our listeners about the system that we are dealing with right now in its current state. As many people are aware, once COVID hit last year, the court shut down in the middle of March, and we're down for quite some time. And then, really everything has been virtual for quite some time, although starting in July of last year, in-person hearings were allowed again to a certain degree, all arraignments, some evidentiary hearings, but we've not had any jury trials really over the past year. That is beginning to change a little bit in some specific areas.
Yeah, John, I think it's would be helpful. Just say, someone picks up an OUI this weekend, today, right? The state of affairs being the way it is, there's such a backlog with cases, and obviously we can do another podcast about, what can you expect, depending on what county you are in, how long things are going to take. But those are the people with the backlog. So you get arrested today. We see essentially the first hearing is going to be in person. Some courts are summoning the people. Some people are overnight arrest and being brought to court the next day. Say if you are then given a personal recognizance to come back on the next day or you make bail, then from a lot of the courts that we're seeing, the next hearings are essentially virtual. And are you seeing also the same things down at the Cape and the Islands?
Yes, everything really South Coast down to the Cape and then to the Vineyard in Nantucket. Everything is pretty much the same. They obviously, as you touched on, some courts vary by, date of arraignment. It's very important that if you are placed under arrest and then bailed out by a clerk magistrate, they're going to give you a blue recognizance slip to appear in court. It's important to pay attention to what that date is. The normal course of business is it's usually the next business day that you would go to court. However, due to some restrictions and due to some backlogs, some courts are putting that out a week, few days. I just had one in Peabody today that was a weekend arrest and a Thursday arraignment. So every court is doing it differently. But that would be the first appearance that is live in person. So the individual would have to check in with the probation department at 8:30 in the morning, and then they would go into the arraignment session and wait for their name to be called. It is important to note that anyone entering a courthouse, there are strict capacity limits. So even for us, we have to answer COVID-related questions and have our temperature taken before we're allowed to enter the courthouse. And so those questions are, similar to what we've all been dealing with for the past year. Have you traveled outside the state in the last 14 days? Have you been ordered to quarantine? Have you been in contact with anyone who's tested positive for COVID? Or are you awaiting the results of a COVID test? To further touch upon your point, after the arraignment, virtually everything else is over Zoom. And for the most part, right, our clients don't even have to be involved. That's just for us really to be on the Zoom call, to tell the judge that we've had good contact with our client and that, we pick a new date. So it's made it a little bit more difficult because we usually would get a lot of our discovery at the court hearing in person from the district attorney. Right. Now there has to be a lot more interaction between us and the prosecution in between court dates for them to provide us with the discovery we need in order to properly advise our clients on what to do.
Yeah, I mean, also too, like we're seeing a lot of judges willing to plead out people on Zoom. Some courts were talking about a couple months ago that it had to be in person, but they seem to put the kibosh on that whole thing in the Boston circuit. That was the only place that I think they were somewhat adamant about it. They're like, well, next time it's got to be in person. But then with all the continued CDC guidelines that kept bumping everything back, they seem to loosen those restrictions a little bit and not hold anybody to that. But I also want to stress, John, too, it's you talked about how when a person gets a summons, you need to look at the date. But if they don't get a summons, they need to look at the ticket, right? Like they may think they're being charged with one thing, but they're not being charged with that at all. And the ticket itself is important. And also the requirements about mailing it back for a hearing. Can you touch upon that a little bit in terms of reading the front of the ticket, reading the back of the ticket, and the importance of talking to a lawyer like you before mailing the ticket back?
So it's a great point. And that is only gonna, if you're placed under arrest, then you're going to court. There's no mistake about it. There's no summons. It's a clerk magistrate telling you when you're supposed to appear. The circumstance you're discussing happens a lot to our clients, and that's when they are hospitalized, right? So they're either involved in an accident or, some of my clients, they've had a medical episode or an overdose, and they go to the hospital. Yeah. So the police typically will not wait at the hospital for them to be discharged and then throw cuffs on them. They will typically cite them, give them a citation right there in the hospital, and leave. Okay, so those people, it's very important for them because they only have 4 business days to request a magistrate's hearing. Okay. And so on the back of that ticket, if it's your classic citation, there's a box down the bottom to request a show cause hearing or a clerk magistrate's hearing. Those are one and the same. If it's the new computer printout tickets that a lot of the state police are using, there's just a box on that one-page printout that you sign and check the box. And then what's different is if you're challenging a speeding ticket or a moving violation, you're mailing that ticket to the RMV processing center. Exactly. If you're applying for a show cause hearing, you're mailing that to the criminal clerk's office of the court, which has jurisdiction over your ticket. And so if you have any questions about that, at the top right-hand corner of the citation, it usually would say what the district court is. If not, there's a court code on there. And that's something you and I know. We know all of the court codes for every court in the Commonwealth. Yeah. So really, it's important if you get a citation to contact us right away so we can best advise you.
I mean, and what people don't realize is that rule is pretty strict. And if you go over that and you mail it to the wrong place, the court's not going to get it. So they'll deem that you waived your hearing. And right. If you waive your hearing, it's a great opportunity for you to get your case dismissed.
Correct.
And it's a shame that it's so confusing, right? It's not explained to people.
That's a great point. A clerk magistrate's hearing is a free bite at the apple, right? Yeah. And so everybody's circumstances are different, but for some people, it gives them an opportunity to plead for leniency, for the police officers to hear our side of the story and perhaps have some compassion for an individual. And we've been very successful in having people diverted and doing certain programs prior to having the complaint issue. And that's huge because if it doesn't issue, it never hits your record. And then It's as if it never happened. And so I can't tell you how many OUIs we've had that they essentially don't exist because of a clerk magistrate's hearing and a person doing the right thing and whatever programs and protocols we put into place to help them personally achieve success. The courts look favorably upon that. I mean, the courts are very proactive in treatment and mental health treatment, substance use disorder treatment. So all of those are things that we try to help with our clients, and the magistrate's hearing is the ultimate forum for that to take place.
I agree. So next time when you come back, John, I certainly want to talk about the state of courts and kind of what people should expect. But I mean, right now, it's certainly being dragged on longer than we normally would see. Normally, we'd see cases, if people are in custody, every 30 days you can come back to court. And when people are out of custody, it's 45 to 60 days. Right. If you're out of custody now, it could be the next court date could be months. It could be months away, and you can really drag out your case to a year and a half pretty easily.
Right. Especially now with cases that are ready for jury trial, all those dates have been wiped out. These cases are being advanced for what's called a trial readiness conference. You're going to report with the district attorney to the judge what you expect, and then that's it. You don't get a new date. The court just contacts you whenever they can start doing jury trials again. So some courts that may be in a month or so, place like New Bedford, I have no idea when we'll be able to do a jury trial in that courthouse again because of the limitations within the building.
Well, John, thanks for coming on. I'll see you next week.
Take care, Jay. Good to see you. Thank you.